Okay, Harley's an attorney that's been working with one of my attorneys that's been trained in all this. I just want to talk about this He just used this. You just used this process, didn't you?
Used it. Yeah.
You just learned about it, right? About a month ago.
4 months ago.
Oh, has it been that long?
Yeah.
Okay.
Time flies. But.
Okay, so he sat in on one of my webinars, and Harley goes, I like that. That makes a lot of sense. So they had a case, and so he went through. So tell me how that went, the explanation, how much sense that made when you took him through, and the impression it had, and all that. So go ahead.
It went very well. First, you know, I had started on the defense side 30 years ago, so there's always a reluctance with attorneys not to use chiropractors because it's the Achilles heel of a case, because you get bludgeoned on, you know, hospital privileges and everything else.
That's in our preemptive strikes.
When we went through the protocol, he had a huge impact on the jury. The jury just was leaning forward. He had credibility. He was like a expert of the spine. And I brought this spine over here. Nolan, can you grab that?
No, don't do that. Don't do that. Can't see it on the camera.
We established credibility with Dr. Shaman. Then I had the spine, and I walked it over, and I gave it to him. He went through the mechanism of injury, the basic anatomy of the spine, the disc, how everything relates, the soft tissue went in through pinched nerve, herniated disc, things that came out in voir dire that, you know, lay terms that everyday jurors understand.
Let me ask you specific questions.
Okay.
So these are the 7 categories that they try to decrease his credibility, right?
Every
so
one of them.
How well did he do with, turn this way if you don't mind, the other way.
Okay. Well, the jurors...
So let's go one at a time. So did we line him up to fend off attacking the doctor's credibility?
Never got a cross-examined. They never even went there after direct. Yeah.
After he did this, attacked chiropractic's credibility. Did they even?
Never even touched
But you handled that, right?
Oh, right.
You had the questions to handle that, right? You see how they're called preemptive strikes. We just bat them down before they get a chance to even come at us. Established pre-existing. You handled that, right? If there was any pre-existing?
Yes, we did.
Okay. Established low impact injury could not have caused that. Did we go into some?
That,
We
yes.
went into the injury magnifiers into some of those things?
Yep.
Low property damage could not have caused that injury.
Didn't come up too much. We had $5,000 of damage, but no visual damage
Okay.
to the target vehicle, the bullet vehicle at 7.
How about we totally took care of the subjective category because we went into subjective, hybrid, and totally objective, and what the differences were, and that the case was based on all of it, not one of it, right?
Correct.
Totally batted that down. That wasn't even an issue. You see what happens? Tried to establish, did they go into anything that's, and again, once it's batted down, it decreases them of even coming at you, and if they do, it's so weak and pathetic right now, it's like crazy.
Yeah, the cross-examination was weak to none. They just relied on their experts. They brought in a biomechanical engineer.
Well, let me ask you this. Is it probably safe to say that it was weak to none because that line of questioning and how he answered it made it weak to none?
Let me just tell you.
He didn't give him room. In other words, he didn't open the door for him.
Protocol, your chiropractor will look like a specialist. He'll look like a rock star. The jurors loved him. They were leaning forward, and when he was doing his adjustment, I asked him, how would you adjust the subluxation at C4? And he grabbed it just so skillfully, the way he handled the spine and everything, they were just drawn to it. It's a big visual when you come in with that white skeleton.
So he not only was able to explain his therapeutic protocol to diagnose, he explained the 3 phases of healing, didn't he?
Oh, the remodeling, the inflammation.
And he explained the need of care and why it was based on the science of the 3 phases of healing, didn't he?
Let me tell you, he looked like better than an orthopedic surgeon. I mean, he covered everything, and it's the I want to call it a flow chart, but the protocol.
It is a flow chart.
It is a flow chart. To it, you put all the facts in there, and the chiropractor will look like a superstar. The jurors will love him. Yeah. Instead of being a weak part of your case, it'll be the strongest part of your case. Plus, you got to lay the foundation.
I was always the strongest. I was always the strongest person in our case. When you do this documentation, this is not taught in medical school. You won't have an orthopedist do this. You won't have a neurologist do this. You won't have them do all this stuff. Thanks.
Yeah.
Appreciate it. Yeah.
Yeah.
Who you face with orthopedic?
Let me move forward. Let me move.
It'll always be Dr. Soul.
Yeah. Let me move forward with this a little bit. And so the point is, the
The testimony with Dr. Sheridan and Dr. Sayao was so cogent, so well. They pulled their orthopedic surgeon, and they spent $67,000 trying the case when they only offered us $4,000.
well, let me ask you this. Let me ask you this. So they spent $67,000 to defend the case when they only offered $4,000. Okay. So my point is, when you do these protocols, when you do the 7 categories, and the doctor does them, and then you do the 12 categories to put the case together to 7, and you put it in sequential order like that. You guys are attorneys, right? What are you going to come at me with now? Come at me now. What do you got? How are you going to come at me? And that's what happens. I actually had an attorney. This happened in court. My client that I trained did this. There's little wiggle room for any attorney, right? And remember, we don't go to court unless we have all our categories, all our categories, right? So we know when we have our categories, I tell the attorney, let's go. Let's go for it. We got it. So the attorney, a couple things always happen. When the attorneys learn this, I already told you, they'll take their existing, now they know what the doctors are using and chiropractors are using. Now they know what they don't know, and they realize that they'll hurt them with that case. And they almost always now ask my guys, the clients I train, they'll ask my guys to be the expert witness because they just met them. So they'll ask my guys to be the expert witness, not the treating chiropractor, because now they know that the doctor, how much you need to know to win. The other thing that happened with this particular case is one of my clients went to court, did everything just like this. The attorney at the end, she tried to attack. There was nothing there. Because remember, we're doing all the preemptive strikes. We're building the case. The attorney literally said to my client in court, threw her hands up and said, "You're a hired gun," and walked off. What did that mean? When she said that, what did that mean? You're Teflon. You're too tight. I can't do anything with this. She obviously lost. But what does it say when you have an attorney, the defense attorney going, "You're a hired gun"? In other words, she couldn't do anything. There was no wiggle room. She couldn't find anything. She couldn't go anywhere.